Thank you all for coming tonight.
Lucky you.
On behalf of the Stanford Center for E-Commerce, we're delighted that you are here. We've got a great program with some great speakers. We started a little bit late, so we want to just jump right into it. We've got on our panel, starting on my left, Chris Wolf, who leads the global privacy practice at Hogans Lovells. He's the founder and co-chair of the Future of Privacy Forum, which is a think tank advocating responsible data practices. And he regularly represents clients with respect to privacy issues implicated by online behavioral advertising and is involved in the analysis and responses to the proposed revision of the European privacy framework. And he'll talk to us about the international landscape. To his right is Tien, who is a senior staff attorney with the Electronic Frontier Foundation, a nonprofit civil liberties organization based in San Francisco. And he specializes in free speech, privacy, and computer security issues. EFF, as many of you know, has filed amicus briefs in many of the more important internet cases. To his right is Jonathan Mayer, who is a graduate student in computer science and law at Stanford, where he is the junior affiliate scholar at the Center for Internet and Society and a cybersecurity fellow at the Center for International Security and Cooperation, as well as a Stanford interdisciplinary graduate fellow. His present course of research aims to shed light on the technical, legal, and policy issues surrounding third-party web tracking. And he will actually start us off tonight, drilling down into some of the technology. And then to his right is Alison Pepper, who is the Senior Director of Public Policy at the Interactive Advertising Bureau in Washington, D.C. Alison is the Senior Director responsible for government relations and communications, including federal and regulatory affairs. Before joining the IAB, she worked as a legislative analyst for Experian, where she covered issues ranging from data security to identity theft, and has extensive experience working in state government, including in particular in Georgia. We've got a very interesting panel. We also have a very interesting audience. And for those of you who've been to these programs before, you know that the Center for E-Commerce likes to focus on practical solutions for companies and likes to bring together ideas from academia, the business world, and law to try to forge new solutions. We want this to be an interactive program. We will not be tracking the interactivity, but we want it to be an interactive program. And so while each of the speakers will have a defined presentation, we feel free to jump in with a question. And at the very end of the program, we're going to have questions, and we want them to be good, interesting, tough questions. So without further ado, let me turn it over to Jonathan to give us a lay of the landscape and the technology.
So thanks for the introduction. So I'm going to try to give an overview of technical issues related to third-party web tracking. There's a line of research that in our lab has been at times affectionately dubbed tracking the trackers. I think you're going to get a lot of tracking puns tonight. Sorry about that in advance. Two-ish so far. Okay, so there are three topics I want to move through. The first one, a look at the history and status quo of web tracking and behavioral advertising, so how we got to where we are and where exactly we are. Then a look at the technology that's used to follow consumers around the web. And last, a look at some of the technologies that are available to consumers to get some control over what websites are learning about them. So to begin, the history and status quo of web tracking. When the web was first developed, everything was static. It was kind of like a collection of documents that pointed to each other. This was the original design of the web by Tim Berners-Lee in '89. So the idea was just like a stack of documents that pointed to each other, and you could follow the pointers between documents. And in 1992, first graphical website, pretty much the same concept. So if you're really cool, you might have some images on your website. If you're really, really cool, you might have some things scrolling from side to side. I think I heard a chuckle. You can tell who the engineers are because they recognize the last two. These features were actually so annoying on the web that web browsers took them out. The ability to scroll stuff side to side or flash it at the user. You may recall this stuff. Like, no one uses it anymore. Now they can't use it. But anyways, that was what the cool kids did. And of course, that didn't last long at all. In 1994, Netscape added the ability to store some information in web browsers and have web browsers provide that back to web servers at a later time, those cookies. And then in 1995, added the ability to run code in web browsers. There's a technology called JavaScript. So by 1995, web browsers were kind of like an operating system. You could store stuff in them, and you could run programs in them. And it became very apparent to people working on web technologies at the time, hey, people are getting a lot of information on the web now. All of their reading habits might be exposed to the websites they're going to. We might want to be a little bit careful about some of the privacy properties of this system. And so in 1997, the Internet Engineering Task Force, that's a technology standards body that works on the web among other technical spaces, put out a document that said, in plain English, this is like the geek version, hey web browsers, you really need to look out for your users. There's a real possibility of privacy invasions here. And so you have to make every attempt to protect your users. So that was 97. By 1998, every single major web browser accepted every cookie and ran every piece of JavaScript by default. So unless you went and configured your browser for special security or privacy properties, it was just going to accept everything. So that was kind of the end of technical countermeasures in mainstream browsers for quite some time. Not coincidentally, in 1997, a company was founded in New York on the premise of, gee, we could follow users around the web, and we could figure out what they're interested in. And then maybe we could sell some ads based on those interests. The company was DoubleClick, later acquired by Google, and now one of the largest behavioral advertising businesses on the web. So OK, that was then, and this is now. So here's a website you might see when you wake up in the morning. Or if you're conservative, it might look like this. But I'm going to stick with just one for simplicity. So it looks like the New York Times, right? It's got that iconic Gothic font. It's got the New York Times coverage that you would expect. It's got the New York Times opinion columns and op-eds. It's even got the New York Times classifieds and obnoxious New York stuff that the rest of the country doesn't care about. So it looks like the New York Times, but it's not all the New York Times. In fact, the ads at the top are from a company other than the New York Times. In this case, they were from Google. The one in the middle there, that was from Yahoo. The videos and images in the middle, those might be hosted by a different company. In this case, the company was Brightcove. On the right, the little social sharing widget from Facebook. So there are loads of companies now putting together the websites that we go to. In the jargon of the space, the website that the user is expecting to interact with here, the New York Times, is the first party, and the sites the user doesn't expect to interact with are third parties. It may not be the best jargon, but anyway, it's what the space uses. OK, so these are the third parties you can see. It turns out there are many more that might not even be visible on the page. So loads of third parties on popular websites. Here's my favorite example of third-party content embedded on a website. Thankfully, the UK National Health Service has changed the design of their pages since, but for a long time, they had the Facebook like button on their disease pages. So you can see 5 people liked syphilis. Great prank idea, by the way. And lest the UK get all the heat, so this is the US National Institutes of Health PubMed pages. Last I checked, this is still live. A different company's social sharing widget is off on the side. So if you go to learn about syphilis at the NIH PubMed Health website, this company add this, learns about your visit. So this is the crux of the problem. Every time you go to a website now that's got this third-party embedded content on it, they get tipped off. There's in fact this entire ecosystem of third-party content that gets tipped off. In fact, it's a really, really big ecosystem of third parties on the web now. The market trend has been disaggregation. So where before there was, in '97, this one company founded on the principle of, hey, we could be this company that places ads based on users' interests and make some money. Now the market's disaggregated into, I'm a company and all I do is figure out what users' interests are. I'm a company and all I do is follow users around. I'm a company and all I do is help show ads. I'm a company and all I do is facilitate ad transactions. So any place there can be some disaggregation, there has been some. So there's this burgeoning ecosystem of companies that are getting information about what users do all over the web. There are primarily three technical mechanisms. I apologize, by the way, there is technical content. I don't know if anyone warned you in advance. But I'm going to try to make it accessible, and please ask questions if it's confusing. There are primarily three technical mechanisms used for following users, or for bringing in third-party content on the web and then following users around. You can embed an image from a website other than the one you're going to. You can embed some code from a website other than the one you're going to. Or you can actually pull in a mini website itself. That's what the third tag is there. So there are multiple ways in which you can bring in content from other websites. And this doesn't have to be visible to a user. So for example, you could load like a 1-by-1 invisible pixel that users never see. That's a very common practice. And so here's how information about the user's browsing history is often shared with third parties. The browser will go talk to some third parties. So here's some hypothetical advertising.com. And then there's this thing called a refer, which is just where the website the user's on now. So here the user's got some news website. And then very often these companies will track users using ID cookies, so a magic number associated with the user. So here the advertising.com company learns user 12345 just went to news.com. So you can imagine replaying this over a bunch of websites, and you start to build up the user's browsing history. And you get a table kind of roughly like this. So you could say, here are some places user 12345 went and when. Here's, for example, something I might see. Well, maybe not the first one, but I do like the squirrels water skiing videos. I highly recommend them on YouTube if you haven't seen them. So this is the information we're talking about. There was a survey the Wall Street Journal did a couple years back where they found there were 64 different tracking mechanisms on the average popular website. So there is an awful lot of tracking technology on sites now. And so in the first instance, what's collected is that browsing history, that list of websites the user's been to and when. That, of course, can include health information if the user goes to an NIH or NHS site, financial information if the user goes to a financial services site or an advice site, a shopping history if the user's going to e-commerce sites. The list goes on. And then, of course, you can analyze this information. It's very rich for information about the user's habits, try to figure out their interests, and learn yet more. I want to take a moment to specifically address the question of identity. Because very often this refrain shows up in the context of behavioral advertising and third-party tracking that, well, we don't have to be too concerned because this is all anonymous. So what's the big deal? In fact, this is such a pervasive idea, it made the cover story of Time. There was this article where this author works through all the information that companies are collecting about him, and at the end he draws the conclusion, well, maybe I'm not so concerned because it kind of seems like it's all anonymous. And the first response I want to give is that, and this is going to seem a little nitpicky, but I promise I'm going somewhere with it, is it's actually all pseudonymous. And that's a very important distinction from the computer science perspective. So pseudonymous data differs from anonymous data as follows. In an anonymous system, if you learn something about a user, and then the user shows up later, you have no way of linking the user you're talking to now to the user that you talked to before. That's very different from a pseudonymous system where the user you're talking to now, you can link to things that they've done before, and you can link to things that they do in the future. You just don't happen to know their real identity. And the reason why the difference is crucial is because just a little bit of identifying information in a pseudonymous system breaks the pseudonymous property altogether. Because in an anonymous system, if you learn someone's identity, and then they leave, and then they come back, and you have no way of linking, right? You can attribute the prior action to the user with their identity. You can't attribute anything else they've done. In a pseudonymous system, you actually can attribute everything the user does to their identity. So a great example of this is the human face, right? That's a pseudonymous identifier. Until you learn someone's name, you say, I recognize this person from back then, and you might be at some event later, and you say, oh, I think I saw this person before, but you don't know their name. But the second you learn their name, now all of a sudden you can go back and say, oh, I saw this person with their name at this thing before. Or going forwards, you can attach their name to things. So the point being, just a little bit of identifying information breaks the whole pseudonymity property. And so it turns out there are a lot of ways identity can get injected into third-party web tracking. One way is there are some companies where it's not even a question. There are some companies where users provide their identity. So a great example of that would be Facebook or Google, where a user might be logged into an account, and then when there's a Facebook like button or a Google +1 button or Google Translate running on a page, they know the user's identity because the user's logged in. There might be intentional leakage. Leakage is just a term of art in the computer science community that works on these issues. Leakage is just a flow of identifying information from a first party to a third party. So intentional leakage might be a first party sells a user's identity to a third party. There are some companies that are in the business of buying users' identities. So for example, there are some companies that will buy a user's identity from an e-commerce site when you go and buy something, and then go match to an offline consumer database, find out information that's in the Experian database or whatever about what you're interested in, and then use that information to target ads. Right? So some companies just buy and sell this stuff. There can be unintentional leakage. I'm going to get to that in a second. There are security exploits that could be used, which I wish I could say that advertising companies are above abusing exploits, but I'm going to get to in a little bit a company we identified taking advantage of an exploit. And then last, there's this whole body of computer science around how you can take a mess of data that doesn't have users' names on it, match it up against a mess of data that does have users' names on it, and then link the two such that you re-identify the unidentified data. So we actually did a study of identifying information leakage from first-party websites. This is things like the website puts your email address in the URL, and then using something like the referrer I showed you before, third parties get sent that information. And so we went and signed up with a bunch of websites and looked for if things like email addresses and names and so on were getting passed along to third parties, just by virtue of how the first parties had designed their websites. And it turned out this leakage was all over the place. So these were the top recipients of leaked information. And remember, just a little bit of identifying information leakage is enough to break the pseudonymous property. So I think it's very fair to say that there are many companies in this business that don't want to know users' identities, don't need to for their current business practices, but for privacy implications, as we think about the privacy implications, there I think is a very clear world of difference between we don't go out of our way to identify users, but they could be identified, in many cases trivially identified, and our users can't be identified at all. Okay, so I've used this word tracking a few times. I just want to be clear about what I mean. I'm talking about the collection of a user's browsing history, which is kind of necessarily by these third-party websites. Since you're going to multiple first parties. So collection of a user's browsing history with a caveat by third-party websites is what I mean. Some people expand the term third-party web tracking. I'm just going to use tracking for short. And there are a few reasons why, from the policy perspective, you might be uniquely concerned about tracking. One is information about what users do on the web could be pretty sensitive. Things like, for example, researching syphilis. This can be identifiable information for the reasons I just gave. So, uniquely sensitive with your name on it. So there's some reason to be concerned. There's not a lot of transparency into what's going on. There's, in fact, not a lot of regulatory intervention thus far, not a lot of legislation covering the space. There aren't really usable and effective technical controls for the average user. And last, it's not really clear that there are adequate market incentives to get things like security and privacy right. Users don't even know they're interacting with many of these companies, so it's really hard to expect users to vote with their dollars. in theory, you could imagine first parties leaning on third parties to improve their practices, but thus far, there hasn't been a lot of that pressure. So there's some reasons to be concerned. There's been a bunch of surveys looking at what users think about this stuff, and the consistent result is a significant majority are unhappy about it. There was, in fact, a new survey that just came out of Berkeley where a majority of Americans didn't want to be tracked and would want control over the collection of their browsing information. Users aren't the only ones who are concerned. There's been a bunch of regulatory and legislative interest. In the US, the FTC, the White House, and Congress have been looking at the space. California the California legislature has been considering some legislation. In the EU, there may already be law on the books. It's a little bit up in the air. I think we'll get into that. In Canada, there's a comprehensive electronic privacy law that the Privacy Commissioner has interpreted to regulate the space somewhat. So I'm going to be sensitive to time since we kicked things off a little bit late. I'm going to hold off on talking about the technologies that are used to track consumers and some of the consumer control mechanisms. And I think instead, if anyone ever asks a question about this, I may have slides prepared. So I think maybe that's the way to go there. Does that seem reasonable?
How quickly can you go through the technology? Because I know people were really chomping at the bit for hard technology.
Okay, like 10. Go. Okay, I'm going to try to move quickly. All right, that plan got vetoed. I know it's not because I'm that exciting, though. Okay, so...
Some of us are from New York, you can talk that.
Challenge accepted? Okay, so there are two kinds of different tracking technologies. There's stateful technologies and stateless technologies. The stateful technologies in the jargon of the space are generally called tagging, and the stateless no? Okay. Right. It was funnier for me.
It was fine for me.
Fine.
Keep going.
Okay. So the stateful technologies are called tagging, and the stateless technology is often called fingerprinting in the jargon of the space. So you may hear those terms get tossed out some. So here are some of the technologies, or let me take a step back. And for those who aren't immersed in web design, so stateful technologies are kind of like slapping a virtual barcode on a browser. Right? So some information, some state gets stored in the browser and gets played back to the server as the user moves around the web. And so that's how the user's activities are correlated. That's distinct from stateless technologies where you don't actually store anything in the browser. Instead, you rely on measuring properties of the web browser as it moves around the web, which taken together can be unique. So I'm going to get more concrete into how each of those works. So here are a bunch of technologies you can use for stateful tracking or tagging. All of these are like totally legitimate technologies. They're the things that make the web great. Now, cookies are awesome. We have shopping carts, and you can save a login, like totally legitimate. Flash storage makes sense, right? So like your YouTube video can buffer, like that's pretty good. It makes sense so this guy down the bottom, HTTP STS, that's a security technology. So it says, if you go to PayPal, only connect over a secure connection, and remember to only connect over a secure connection going forwards. Right? So these are like really good technologies we want to have in web browsers, but all of them can be used to store a little bit of identifying information about the user. And that's all it takes to identify the user as they move around the web. And so we've done some research, and other computer scientists have done research trying to identify which of these technologies are in use today. There is a company that some researchers at Berkeley identified that was using all of the technologies in red boxes. They were actually, if you cleared your cookies, recreating the tracking cookies from the information stored using these other technologies. The jargon in the space for this is zombie cookies. So, really? Okay. But true, there are actually news articles talking about the rise of the zombie cookie. So there was one company using all of these technologies. We identified another company that was using these two technologies. So one is so things speed up and when they load in your browser, and one is for managing versions of things that are cached in your browser, saved in your browser for performance reasons. This company was Microsoft, so not small fish. We identified another company that was taking advantage of what was actually a loophole in the way browsers were designed for, or the design of browsers for styling websites, where you could get access to browsing history. This is what I meant when I talked about how some companies might go so far as taking advantage of security exploits to learn about users. So let me go into a little detail on this one. So you may recall if you go to a website that doesn't actually have any sort of fancy styling on it and you haven't been to a link, it's blue and underlined, right? Like this is what websites that don't go to any effort to look good look like. You never know how good a projector is, so, all right. Okay. So right, and if you have been to the website, then it turns purple, right? So the exploit was, this is very clever, you create a bunch of links to websites you want to see if the user's visited, and you just ask again and again and again, is it blue or is it purple? Is it blue or is it purple? And the browser would tell you. And so now you can see where the user's been on the web. And you could actually do this with invisible links, so that the user never actually saw it. So this was like something that was known could be done. There were in fact some companies that had been identified by other researchers. They're doing this. We found a company that was doing this in ads on some websites. They're testing about 15,000 to 16,000 URLs, including URLs at the NIH, Mayo Clinic, IRS, and Federal Trade Commission, looking for information about whether you were trying to get pregnant or entering menopause, or had bad credit, were underwater in your mortgage. It was a very unique look at what these companies were trying to learn about users. So they stopped, by the way, after we suggested this was maybe a bad practice. Okay, so those are some of the ways in which you could learn taking advantage of stateful technologies. Here's some of the ways in which you can use stateless technologies. So these are all properties of browsers. So like your screen resolution, or what sorts of file types does your browser extension support, what fonts do you have, and so on. All of those things which individually aren't particularly unique, but you take them together and you get a fingerprint of the browser. And it turns out that you can use these fingerprints to follow people all over the web in a very robust fashion, in some cases more reliably than using cookies. And there, in fact, I mean, no one's surreptitious about this stuff. There are companies whose sole business model is predicated on following people with fingerprints. There are companies that are very open about doing this. So these aren't like hypothetical, companies could use these technologies, companies do use these technologies. Okay, so that's stateless technologies. And I want to recap by reiterating my thesis on these issues, that the technologies that make the web awesome are the very technologies that enable tracking. Right? We can't get rid of tracking like at kind of a fine-grained technical level. There is no way, because we're talking about things that users want and now kind of need in their web browsers, and things that websites use every day. So there is like no quick technical fix here. Yeah?
So when you were stopping at these various websites, is it attaching something to your viewing history that those markers you move around, or is it some other methodology?
So all of these technologies could work. The stateful ones work just like ID cookies, right? You have a magic number that gets stored in the browser and then repeated to the server wherever the user goes. The only difference is in where you store that magic number. So with a cookie, you use this mechanism called cookies that's built in the browsers. For example, the e-tag mechanism. So this is a mechanism that works where your browser goes out and says, give me this image, and the site can say, okay, here's the image, and by the way, this is image version 5. And then your browser later goes, okay, give me this image, and by the way, I already have version 5. And the server can say, oh, okay, it hasn't changed as version 5, so just use the version you've got, right? So like a technology that's not really in any way intended for storing information like tracking information. So what Microsoft was doing was, instead of storing version 5, they were storing the user number. And so when you...
And I think the question is it on the user's computer?
Yes, so that number's on the user's computer, but you're not saving the user's browsing history in some file that then gets repeated to the server. So Hopefully that answered the question. The mechanism is this kind of virtual barcode that gets repeated. It's not actually like some file gets bigger and keeps getting sent as it gets larger to the site. Okay, great. All right, so that's all I wanted to say about tracking technology. So the last space I wanted to be sure to address was technologies for consumer control over tracking. There's some technical countermeasures available to consumers. The most effective, the ones getting the most attention these days, are quite crude blocking for the reasons I gave before, that there is no real kind of scalpel-like technical fix here. And so the technologies tend to focus on, okay, we're just going to stop the browser from talking to the websites that seem to be in the business of tracking. Like just cut off communication, full stop. There are a bunch of software packages that will do this for users. In some cases, browsers are beginning to build this in. So Internet Explorer 9 and later has a feature called tracking protection lists that'll let you block websites. Here's what one of these lists looks like. So it's actually just like a list of patterns that gets loaded into the browser. And if something matches an entry on the list, it gets blocked. The browser won't talk to it. And you can also whitelist things. So you say, well, if it was otherwise going to be blocked, nevertheless allow it. And that's going to matter in just a moment. So critics of the blocking approach have said, well, this is kind of weird. We now have this like cat and mouse game or arms race between users and blocking tools trying to prevent these websites from following users around, and companies who are working around these. And we actually did a little bit of research looking at one of the blocking tools that's most prevalent, not quite blocking in the sense I've talked about it so far, a cookie blocking feature, so a more selective blocking feature, but nevertheless. We looked at what's probably the most widely deployed blocking feature out there. There's in Safari, Apple's web browser, which by default prevents third-party websites, so where the domain name of the website varies from the one you're looking at. So if you're like on nytimes.com, then yahoo.com can't set a cookie, is the general idea. So there's this feature built into Safari, enabled by default. And it turns out there's some ways of working around it by being a little bit clever. In short, you fake an invisible form and then fake the user clicking on that form. This was known. This was something that had legitimate use cases, but was certainly a privacy risk. There was no doubt that a company could surreptitiously take advantage of this and negate the whole feature. So we identified 4 companies that were taking advantage of this. One of the 4 companies that was placing cookies in Safari browsers despite the feature was Google. So there's no doubt that if privacy features get sufficient adoption, there are going to be some efforts to work around them. And that's certainly not a constructive dynamic between users and websites. But setting aside that, I think there are a bunch of other problems with the blocking approach. It's not comprehensive, so you only block whatever is on the block list. So if you don't get the right list, you're not getting all the protection you might want. Requires updating, so people have to manually tailor these lists. Your browser has to go fetch lists, so if whoever was providing your list goes away, now you have to know that that's happened and go find a new list. It breaks things, so if you want to prevent Facebook from tracking you, you now have to get rid of the Facebook like button. And as one of my colleagues put it, anything that breaks the Facebook like button is no solution at all. And last, and I think this is the fatal objection, it requires users to know stuff about these lists. They have to make an informed decision about them. And these lists tend to be accompanied with a fair amount of bluster. Here's some things that some of the list providers said. Complete control over online tracking, turns out it wasn't quite. And I'll get to Trusty in just a moment, helps users get good ads without compromising personal privacy. So we did this study looking at how these different tools perform. It turns out they're all over the place. It's like, how on earth are users supposed to figure this out when the things advanced by Trusty, probably one of the more recognizable names, actually don't buy you that much privacy, and the one in the middle that was the most effective from an anarchist, as best I can tell, an anarchist collective in New Zealand represented by a guy who wears a gas mask, does the best. Right? So how are users going to figure this out? And to make matters even worse, there's this whitelisting property. So it turned out the Trusty list not only didn't protect you, would override other lists you had installed to allow clients of Trusty to follow you around the web. So not only do you have to install the right combination of lists from the anarchist collective, but if you install the wrong extra list, it overrides and wipes out all of the stuff you've done to protect your privacy. So how on earth do we expect users to figure this stuff out? There is another mechanism available, opt-out cookies. There are a couple of self-regulatory consortia that offer these. One is the NII, another is the DAA. 75 to 100 companies between them. And there are some technical issues with these. Not every company is involved. Like Facebook, for example, doesn't participate in these. They have to get updated, so you have to, if a company starts participating, you have to go back to the self-regulatory website and get their cookie. So these are websites you can go to. You get cookies that say, in essence, instead of ID equals 1, 2, 3, 4, 5, ID equals opt-out. So the site knows not to follow you around. So you have to update if there are new sites participating. And then I think the really fatal objection to this approach is you can accidentally clear the cookies. So often users are told, clear your cookies to protect your privacy. Well, if you clear your cookies and you've got these opt-out cookies, you blow them away. So now you've undone the privacy protection you were trying to do. I'm going to skip over the add choices icon, which I imagine we're going to get to in discussion. There's some problems with that. The kind of policy reason hooked into the opt-out cookie technology that I think is also really fatal to the design is that opt-out cookies don't actually opt you out of the collection of your browsing history. They just opt you out of the targeting of ads. So companies still collect your browsing history. They just stop showing you ads based on the browsing history, which I think is totally deceptive. And it also turns out very few people use it. So we've been doing a study trying to estimate how many users take advantage of this. And it turns out that about 0.03% of browsers have some industry opt-out cookies set. So really, really, really low usage of this. OK, so the last technology I want to talk about is do not track. You might have heard of it. The idea is to design a technology that's universal, so works for all companies. User doesn't have to update. One click, really easy in the browser. You make your privacy choice, and you're good to go. The technical mechanism is an HTTP header, just like the refer business I showed you earlier. So that's all it looks like. That's the technical design of do not track. And it's really easy to receive a do not track header and act on it. All the major browsers except Chrome have implemented support, and Chrome is prototyping support now, so coming very, very soon. That's what it looks like to turn it on. Really easy. It's used by a number of users already. About 10% of Firefox 4 and above users globally. About 20% if you focus on US and EU users. So tens of millions of users already. Those usage numbers are going to go up quite a bit with Internet Explorer 10, where Microsoft has a pre-selected option in their install or first run settings to turn on do not track. So that's probably going to increase adoption significantly for that browser. There are about 25 third-party websites that honor it right now. And the DAA, one of these self-regulatory consortia of advertising companies, has committed to honoring DNT, but with the asterisk of not honoring it if it's on by default, which they think the Internet Explorer 10 thing is, and also linking it up to this not targeting ads view of do not track, not linking it up to the stop collecting users' browsing histories view. Do not track, by the way, people sometimes criticize as being unenforceable. It is enforceable. There are broadly two ways you might technically enforce it. We've done some work on the first, where you try to catch websites that are tracking users despite a do not track promise. We built a tool that allows regulators to try to detect this. Some regulatory agencies are already taking advantage of it. So do not track is enforceable. I'll be happy to talk about how later. OK, so I have talked an awful lot. I appreciate the understanding. Hopefully, at least somewhat entertaining. You have a question? Yeah.
Yeah, about do not track. Is it understood to mean the same thing across the browsers? And what does it mean? Does it really mean no tracking at all?
Maybe I should suggest, I think we're going to get into do not track a little more now. So I don't want to hog more airtime. So I'm going to go sit down now.
Thanks, Jonathan. Lee, why don't you?
Sure. So Jonathan has just given a really, really nice introduction to this whole area of tracking technology. And what I want to talk about then is sort of more of the policy aspects of it, and including the entire sort of do not track idea. And as should be clear from what Jonathan said, the do not track approach is fundamentally a cooperative approach. That is, unlike, say, the kinds of ad blocking techniques that he described, which are things that you and your browser can unilaterally do. A do not track header, that signal, DNT1, is simply a signal. It is, I will liken it to like wearing a button that says, don't track me on it. But it's just semantic. It is not actually doing anything, any technical work. And so sort of in response to your question, really the trick with do not track, once you have got the ability or the sort of universal ability to say it, really, that's what browser implementation means. The consumer can now say, don't track me. So the question is then, what is the meaning or accepted standard meaning for that when a server, when one of the 64 third parties on a website gets that do not track signal? What are they supposed to do? That's a big question. And then, of course, they only have to do it if they've sort of agreed to do it right now, because there is no binding legal obligation. There's no independent law or FTC regulation or anything says that says that if you see a don't track me preference, you automatically have to honor it, at least right now. So in the current where all the action is happening with do not track right now is currently either is really in a group called the World Wide Web Consortium, or W3C, and for more than a year now, I guess, there has been an effort to try to build specifications for do not track in two ways. One, on the technical side for the expression and technical response, and then on the policy/compliance side. And so that's an effort that my organization, the EFF, is heavily involved in. Jonathan's also involved. Alison's organization is also involved. We're all sort of in the room in this W3C process. It's a little different from other things that the W3C has done in the past. It has largely focused on technical interoperability standards. This has a stronger policy component, I would say, than a lot of the things that they've done before, although clearly even interoperability and architecture, we always say architecture is policy. There's always some sort of policy dimension there. But it's a little more explicit, I think, in this situation. So we have this sort of very general state of play on do not track in the W3C. And part of the reason why it's there in this kind of standards organization in a consensus and voluntary mode is because right now there's not a whole lot of likelihood, or there certainly hasn't been for the last year or two, of any kind of actual government action on the United States side. There's always been a little more interest on the EU side of things, and Chris will talk more about that, because they have a pre-existing regulatory framework for privacy. But in this area online, this kind of data collection and these kinds of activities are really largely unregulated by US law. So that's why we have this sort of issue around the user's privacy in this space. I just want to hit a couple of quick points before yielding the floor, and that is there is a recent study that just came out last week. It's entitled Privacy in Modern Advertising. Most US internet users want do not track to stop collection of data about their online activities. So one of the debates, right, is, well, what does it mean? And the study sort of proceeded by asking the question, well, first it found out that I think 87% of the Americans interviewed had never even heard of do not track. Only 13% had. And so they decided after they realized that they should ask maybe a different question. And so they asked, well, if we had something called do not track, what would you want it to mean? What should it mean? And the study was pretty clear. People say that they don't want to be tracked, and that means that they don't want websites to collect data about them. And this is consistent with with research that we've seen before. The other part of the study that's interesting is it says, well, why? Why is that? And the researcher, Christopher Wolf, who's up at UC Berkeley, thought that it might have something to do with advertising. And the findings in the study were that people say that they do not value online advertising. Now, obviously, that's just what people say, right? That does not actually say anything about what they really do. But it is a kind of evidence that I think, or we would argue, demonstrates there's a tension between consumers' expectations around this behavior and the industry business models.
The question
Yes.
I'd like to interject is, particularly when you put it in those terms of consumer expectations, it raises the issue for me of how robust are these surveys that ask people the question. Because I think we know from a lot of survey areas, you ask people a question about something they think have not thought about, and the reality is they have no opinion on it, but you can precipitate polarity one way or the other, and I wonder if, I'm not even sure how you figure out whether consumers care about this.
Well,
If in fact they have no expectations because they haven't thought about it, and probably many of them, if they did think about it, presumably realize it's not a coincidence that after I've gone to one website and something, in some ad area, I'm getting 50 ads for it.
right.
People must, I think, understand that. Why do we think they really care? Other than, would you prefer to have it or not have it? They'll say, no, I don't want it.
Well, I mean, first of all, the study's really easy to find. It's on the web. So I encourage you to look at the study methodology. You see what questions they ask. And I wasn't going to read the sort of, there's always a large percentage in these studies that say don't know or.
But one of the questions
or
could have been
refuse.
Jonathan's questions. If you couldn't have all these features on your web that enable the web to be so great, would you want to be tracked or not?
Well, and it absolutely didn't ask that, right? It didn't ask any trade-off questions, right?
Ask people, would you rather have free TV without ads or free TV with ads? You're going to get 97% of the people saying, I'd much rather have it without ads. I just
Right.
had a federal judge say to me, look, in a hearing, look, we all know that the quid pro quo for all this free stuff is you watch ads. I can take judicial notice of that.
Right. So there are some questions in the study that actually pick up on that, right? And again, if you look at the study, I think it's pretty fairly designed and open because all the points that you're making about what it doesn't say are pretty clear. It doesn't ask those questions. It does test things like, well, do you have different expectations about a free website versus a non-free website? And certainly there's information about there that suggests that people have an awareness that advertising means the use of information in some way. So there's a whole lot of, there are a lot of really interesting questions that we could use, I think a lot more empirical research into. One of the reasons why this is a tough area is, as Jonathan was showing us, there's a huge amount of what's going on the web that people aren't aware of in the first place. And so even to sort of like ask the right question is going to involve sort of, there's a certain sort of observer principle that's going to happen as you educate them to the point where they can understand all the trade-offs. But my point is simply that if you take the basic idea that people are thinking about what they expect or what they would like to be able to ask a website or third parties to not do, it's very clear from this study that and the previous studies that the issue is about collection of information and not merely about the use of information. And that's sort of the point that I wanted to make. We can certainly disagree about the numbers and how deep and shallow they are. People may be willing to agree to some level of collection or use at a different price point, right? There's no question about that. But sort of where we're starting from is sort of just establishing a baseline, and I think that's sort of the relevant point here. So I wanted to quickly review what have been the issues in the W3C on the do not track standard. And it really boils down, I think, to first of all, the collection versus use issue that we just talked about. The FTC, for instance, has had this idea that, well, there's certain kinds of conventional or normal uses of data that people don't need to have consent for. And so one of the ideas in the do not track area is, well, aren't there going to be uses like security, click fraud, that we're not going to worry about shutting off if someone turns on do not track. And so there's a big debate about what those uses are, what their scope is, how they're defined, what kind of data would be involved. Obviously, there's also a question of how much data is affected in the first place. There is a scope question about first and third parties. We started off in the W3C largely because of the Federal Trade Commission thinking strictly in terms, as Jonathan described, really a third-party tracking. But obviously, first parties collect a great deal of data as well. And that is an issue that people will open up. And then the last big issue that kind of came up late in the game, it really came up because of what Jonathan mentioned about Microsoft and Internet Explorer 10, was a question of defaults. This process in the W3C had been fairly light in terms of user interface. The idea was that user interface was sort of out of scope for a lot of it, and then then when Microsoft caused or changed sort of the way it was thinking about how do not track would be implemented in IE10, that caused a lot of people to say, wait a minute, what's going on? That's not what we thought. And that's been a very, very big issue in the W3 since then. So I'll stop right there.
So we've heard the consumer perspective, and we've heard some of the business perspective and some of the questions, which suggests that I think a lot of us have found that certainly when you ask the question, no one wants to be tracked if that's the only question. On the other hand, no one wants to pay $19.95 a month for YouTube or $100 a month for a browser or things of that nature. So Alison, from the advertiser's perspective, how do you see these issues?
So my first responsible experiment I did, like everyone else in this panel, we all do a lot of public speaking in various venues on this topic. And I know one point that I've said a lot in public venues is the fact that, like this gentleman over here mentioned, a lot of sites and services are free because they are advertising supported. They are not a subscription model. And I've said that so many times that I finally decided to be less lazy. And I sat down with my computer this morning and I pulled up my browsing history of the last 24 hours, just out of curiosity to see my own site breakdown, out of how many sites I looked at were advertising supported. And I came up with 13 out of 13 different websites I had looked at in a 24-hour period, 8 were purely ad-supported websites. Now, some of that might, obviously represent my bias over knowing more about these different sites, but a lot of them are sites I think most people would be familiar with. So just for whether or not to bore you with this or not, these are the 13 sites I pulled up. The first was Ping. Anyone who's ever done wedding invitations knows what that is. It's a free service to send out wedding invitations. It's an advertising supported model. Google, New York Times. I'm not a New Yorker, but I do care what goes on in New York, so I do read the New York Times. LinkedIn, Deuce, it's a blog from a housewife in Utah. It's ridiculously entertaining. It's advertising supported. Tabardin, it's a hotel, not advertising supported. CNN, advertising. Patagonia, e-commerce. Washington Post, advertising. Amazon, e-commerce. United Airlines, e-commerce. NOAA, government. And then Pandora. So out of the 13 different websites, I came up with 8 that were actually ad-supported, which was interesting for me, to be honest, until I actually pulled out my own browsing history and looked at it. I was surprised that it was that high myself, that I don't actually pay any subscription for 8 of those 13 websites. So with, unfortunately, boring you with my little browsing experiment this morning, Jonathan and Lee have obviously done an excellent job of covering the technology side of it and how it works and discussing about what's going on in the W3C process. I want to take a slightly different track for multiple reasons. One, of course, that I am not nearly the technologist that Jonathan or Lee are, so I want to take a little bit different approach. One, I want to talk just briefly about a little bit about the advertising business model. I feel like I assume that people know about the model and these type things, and want to go into that a little bit further. Then I want to talk a little bit further about some of the self-regulatory efforts, and Jonathan mentioned a few of them initially in his presentation, but want to go into a little bit more detail about those efforts. So the IAB, I think this is the Internet Advertising Bureau, but it's the Interactive Advertising Bureau. The IAB is an organization that represents what's called in the industry the sell side of the industry. And the sell side, there's basically 2 sides in the advertising industry. There's the sell side and there's the buy side. And the sell side, to put it in the most basic terms possible, the sell side means that, for instance, I'm the Washington Post, and I have inventory on my space that I want to sell to advertisers. So I have space to sell that I sell to advertisers. So the buy side of the advertising industry is, for instance, it's advertisers and it's advertising agencies. So the agencies, kind of the Mad Men, right? Mad Men model. Mad Men is an agency that works on behalf of advertisers. So that's what you have on the buy side of the agencies. You have advertisers, and you basically have their proxy, so to speak, which is the advertising agencies. So that's just the real basic 20,000 sort of foot view of what's going on here. And I think what's interesting, what you've seen a lot in the advertising and in the news industry in the past, you've seen it more in the past 5 years, but it didn't start in the past 5 years. It probably started, not coincidentally, I think 1997, DoubleClick was the date you gave. Probably not coincidentally, you started to see what was happening in the industry with the newspaper business. And I'm sure everybody's heard a lot over the past couple of years, more and more newspapers going out of business, right? You're seeing consolidations in markets where there used to be 3 or 4 daily papers. There's now only one, if there's even one, if they've all gone out of business, or it's just national at this point. And what's happened, so there's good and bad side to everything, right? The good and bad side to technology. And one of the, the accessibility of content when newspapers and other content started moving online, the ability to bring more readers and bring more audience to their site and open up to a much larger universe, it had a good and a bad effect from an economic perspective. And the good and the bad from the economic perspective is why you opened up your audience significantly to how many more people you could reach. What you also did was basically increase the supply or the inventory of how much advertising was online. So while the money being spent by advertisers didn't really change too significantly, their ability for where they could spend that money changed pretty significantly as well. So you saw, that's one of the reasons basically you started to see a lot of newspapers and other content, magazines, et cetera, getting so pressured on their margins was because of this supply of inventory basically greatly exceeding the demand that advertisers had to spend. It's interesting, I think that most people know this, but maybe it bears repeating. But for instance, the local newspaper model, it's not as if your subscription ever really subsidized your whole cost of the paper's overhead and the paper's operating costs, et cetera. A lot of the revenue that supported the paper, from the content to the reporters to the printing, when we were still printing things and sending them out, was subsidized by the advertisers. I mean, the subscriptions alone were, yes, they helped towards the model, but they didn't underwrite the entire endeavor. Advertising did a lot of that. Well, what happened is we sort of all started transitioning to the online model. Is from a business perspective, what sort of happened is with this increased supply, but not necessarily more advertiser dollars being spent, newspapers and other content producers were under a lot more pressure to be able to maintain their businesses and be able to repay their reporters and get their product out and fact check, things that we all consider important in the sort of content industry. So it's probably not a coincidence, I think, from a historical perspective, that probably when you started to see the rise of the beginnings of online behavioral advertising, or OBA as it's called in the industry, you started to see the pressure on newspapers. And people always ask, well, is all advertising basically on content science, is it all OBA? And the answer is not. A lot of it's purely still contextual advertising. And contextual advertising is, for instance, you're reading the travel section of the New York Times, and you're reading, I don't know, let's say you're reading an article about St. Martin, and you see an advertisement for United Airfare to St. Martin. That's probably a contextual ad based on the fact that you're reading a travel article about traveling to St. Martin. That's contextual. What we are still talking about in this debate is online behavioral advertising. There have been some studies done showing that online behavioral advertising is more effective to consumers to the extent that they see it and they're more likely to respond to it. Now, a lot of studies, like the Berkeley one that came out last week, still show that, quite frankly, most advertising online, consumers either don't see, they don't notice, they don't click on, et cetera. It's virtually ignored by consumers. There's still, I think, at this point, a small percentage of consumers who are still paying attention to it. But one of the ways that advertisers have been working to get consumers to pay more attention to their advertising is the OBA. The idea being that, well, you were interested in this service, you were interested in this product, maybe if I show it to you in a different context or I show it to you more than once, you'll be more interested in it. And sometimes that works and consumers do respond to it and like it, and sometimes it actually backfires, like the instance where you see the same 5 ads across 5 different sites, you're not interested. So to say that OBA, or you already bought the product. I know.
Right.
Doesn't know that, though. If they knew that, then they'd stop.
Yeah, no, I bought a car 5 months ago and I'm still getting ads for the same car 5 months later. So to say it's perfect as a business product either is not true as well. It's not perfect as a business product. So I just wanted to give that quick background because I feel like that's maybe not always a perspective you hear about sort of how we got from where we are to where we are now. So that's just the quick sort of background in the 101 on the advertising industry. One of the things that the IAB has worked on since about 2008 is what Jonathan mentioned is the self-regulatory programs, one of the self-regulatory programs. It is not the only one. And the IAB in 2008 got together with other trade associations that represent a pretty broad swath of the industry, over 5,000 companies in entirety. And one of those trade groups represents advertising agencies. One of them represents national advertisers, so Kraft, Coke, all big national advertisers. Other ones represent direct marketers. Other ones represent the NAI, one of the ones that Jonathan mentioned as well. And in 2008, this group got together and started working on self-regulatory principles. The 2008 self-regulatory principles were kind of the outgrowth, I shouldn't say kind of, they were largely the outgrowth of, in 2007, the Federal Trade Commission began holding what they call a series of town hall hearings about behavioral advertising because it had been brought to their attention and they were interested in it. So they started holding a series of town hall meetings, and I think it was late 2007 is when they began holding these town hall meetings. And one of the things that the Federal Trade Commission came to industry, and by industry I mean all the 5,000 plus different players in that ecosystem, one of the things that the Federal Trade Commission came to these groups and asked was, well, we think there are consumer concerns, both legitimate and perceived, about online behavior advertising. We want you to start working on a program to address. They asked for several different things, but the 2 main things were transparency and choice. We want you to start addressing a program of how you can provide consumers transparency and choice. So in 2008, I think winter of 2008, these different groups all got together and for about the next year and a half, started talking about ways to provide this notice and choice. And the way that they decided to provide the notice and choice was, Jonathan had a screenshot of it up there. It was sort of the forward eye on the sites. So you see a lot of them in the corner. There's actually been over 1 trillion different ads delivered at this point. And the idea is that consumers have noticed that an ad is being delivered, that it's OBA, and that once you click on that ad, you can link to a series of choices about being able to opt out of tracking. Now, Jonathan pointed out the flaws, which I know is not the first time, and they're all legitimate flaws. There are, if you do clear your cookies, it is a cookie-based system. If you do clear your cookies, you do have to opt back in again. But at the time, when the industry was working with the Federal Trade Association, this was the approach. The Federal Trade Commission was advocating to industry and that this was the approach that they wanted to see, that this was the appropriate and a useful way to give consumers notice and choice. Now, again, it's not perfect. It's not a perfect program. It's still something that's very much in flux. It's still something that has been evolving. It was first introduced in July of 2009, and then based on some follow-up conversations with the Federal Trade Commission, the Federal Trade Commission came back to the industry and said they were concerned about OBA being used for insurance eligibility. They were concerned about OBA being used for any sort of credit underwriting. They were concerned about employment. So we came back and drafted another series of principles about OBA not being used for those restricted purposes. And then going forward, I think it's not any surprise that so much of online activity has moved to the mobile environment in PDA. So one of the things this group is working on right now is taking these principles and applying to the mobile environment. I think it's proven to be a bit more challenging than first anticipated because it's a fairly complicated ecosystem. But I guess my point in talking a little bit about the self-regulatory principle is that it's an evolving process, and it is the first effort that these particular groups have made in this area cohesively. It's something that I think as of September of this year, one of the web choices, one of the web pages, youradchoices.com, got its 11 millionth unique visitor to the site. So consumers, maybe not as many as you'd like, not as many who could be driven to the site as possible right now. Consumers are visiting the site. For a site that's been around since I think about mid-2010, to have 11 million unique visitors is not a bad number. Now, to this gentleman's point about to what extent do consumers care, to what extent do they decide to exercise their opt-out options at this point? Some do and some don't. It's just an issue. I mean, how interested are they? I don't know. It's an issue of when they get there, the information's there, you provide notice and choice, and hopefully you continue to evolve the program as you go forward, which I think is something that industry is working on in different areas, both with federal regulators, but surprisingly also with state regulators as well. Quite a few state regulators are interested. I'm sorry.
I think there's actually a massive amount of real data out there that's not survey data. I'm curious as to whether anyone's looked at it. You're mentioning Pandora triggered thoughts of mine. I've long said that a really good rule on whether you can use behavioral advertising or advertising should be if you offer your service as a completely clean, no advertising paid service as an option at a legitimate price, then you can do whatever you want on the advertising version, and people have a choice. You want the ad version, you want the paid version. I'm just curious as to whether anybody's studied situations where people have had that choice. Pandora and I think Spotify are bad examples because when you choose the paid version, you also get more bandwidth, more mobility. So it's not really apples to oranges. You're not getting the same product, either ads or paid. But it strikes me that there are tons of apps out there now where your choice is keep using the free one and look at the ads, be tracked, or pay for the ad-free one. And I wonder if anyone has done any studies on that ad that's out there. I mean, there exists data for each of those apps. How many people actually paid money to avoid the advertising?
But that's a distinct advertising and tracking.
Well, yeah, but most of the advertising out there is behavioral.
It's not true.
Or at least certainly a lot of it is, and you can certainly figure out which ones are. I wonder if anybody's ever gone and looked at the real data as to
You mean?
But I
choice between free products paid for by ads with ads with all of the ad technology versus pay the actual cost of the service. Which way do people vote with their dollars?
Unfortunately, my example is personally anecdotal, but it's a Pandora example because I actually talked to someone there recently. They still rely really, really heavily on their advertising dollars. I mean, they've had a high subscription rate, but because the way they pay for their royalty licensing, it's a fairly expensive overhead. So they still rely very, very heavily on their advertising.
And again, but the problem here is that when you buy the paid version, you also get better bandwidth.
Yeah, it's not an apples to apples. I mean, I would take, the only thing, and I only thing I would take maybe a little bit of exception to is I don't subscribe to the theory that just because you want a free service or product with advertising, that it's a license for any of your data to be collected and used at will. I don't think that's true.
Right, but at least if you let users actually make that choice in your product, do they want a paid product or do they want an ad-supported product? Then one, that's better for users, and two, we'll get you some real data.
Yeah.
Well, I think the distinction, though, that needs to be drawn is between the contextual or the OBA versus non-OBA. So one of the, because there are two different aspects for the consumer, right? There may be consumers who know nothing about the tracking, the data collection side, but they don't like ads. Another is there are others that may not care about the ad. They may be fine with ads, but don't want the collection of data that goes with it. And so the relevant test for us, because EFF is an organization, we don't have a problem with ads per se. Our dog in this fight is the collection of the data. So I think that the nice test would be between a ad-supported that was non-OBA ad-supported versus something that had OBA. That might be another point, right?
All sorts of gradations.
I'm curious about something a little bit unrelated to this, but how much information about the method, modality, and time of collection is available for the advertisers? In other words, the people who are purchasing data, especially since it's coming from so many different sources and then being manipulated and presented, how much of this is still, is it opaque, or are they very clear on what the sources of that data are?
You mean like when the advertiser, the agency is?
When they're buying.
A lot of times when I've talked to advertising agencies, they buy based on like a characteristic set, right? Like they want between 45 and 55 or male and female. I mean, do you mean like, do they know to the granular level, like where the data that where they're buying the inventory is? Is that your question?
Yeah, I mean, I'm basically, what I'm interested in knowing is how much of the methodology of collection and permissions or whatever was, where it's basically where the data is coming from, how much of that information is flowing through with the data as it's manipulated or put together in different forms.
I think it's probably a little bit different for every advertiser. I mean, I have seen a lot of contracts, the contracts for this, and there's a lot of limits that they put on the kind of data flows between the different, between the publisher or the agency, the advertiser, whatever. They put a lot of limits on a contractual basis. I mean, with obviously following regulatory and legislative and everything being the first stop. But I mean, as to how much sophistication they have, it depends, I think, on the advertiser or agency.
Did you, I didn't catch the question.
I can't hear.
Was the question the extent to which information that intermediaries in the ad ecosystem might hold identified or identifiable information?
Like a data retention type question?
Well, do they have it in the first place? And then if they do they keep it around?
Yeah, I mean, it's a little bit different for everyone, how much they keep it or don't. But I mean, from a pure business perspective, it's stale pretty quickly, a lot of it.
So there are some companies that retain this data. So for example, in the W3C working group, some companies have argued they need to keep this data around for 7 years. Some companies have been of the perspective that, well, maybe we'll only keep it for a couple of months.
This is a contentious issue. The rationale that we have heard in the W3C is that Sarbanes-Oxley, for auditing purposes, requires data at a per transaction level. The analogy has been to say, you buy groceries at the grocery store, that for auditing and purposes, they have to keep the exact sort of market basket, and so that the impressions and the clicks and the IP addresses to which they have been shown and the cookies, that's the assertion. I'm not a Starbucks guy, so I haven't been able to figure out what's going on, but certainly the SEC's guidance on Starbucks for the auditing entities is that they're supposed to keep that data for 7 years. So if that's the case, then there is, if they're right, then there's a legal requirement for them to retain it for 7 years. I question that, but like I said, I'm not a Starbucks guy.
Well, that's an interesting transition to Chris's comments about the European approach, because of course in the U.S. We have largely a regime of self-regulation where companies try to regulate themselves and class action lawyers try to take advantage of that opportunity as it may arise. But Europe has a very different approach and may be driving a lot of the debate. Chris, do you want to outline that?
Sure, and in fact, in Europe, unlike in the United States, privacy is viewed as a fundamental human right. There are other fundamental human rights that are to be balanced occasionally against the right to privacy, but it's viewed, most would say, much more seriously, at least on paper, on the books, than it is in the United States. That's what happened when the EU came into existence. There was the passage of a directive that was intended to implement the full fair information practice principles. So to provide consumer notice and control and choice and purpose specification and use minimization and retention limitations. And if I wanted to make short work of describing to you how online tracking is handled in the EU, I would simply tell you that online tracking requires consumer consent. Then I would stop, and you would know very, very little about the complexities of cookie regulation in the EU. So I guess I better say a little more than that. Until 2009, things in the EU were pretty straightforward when it came to cookie regulation. Under the e-privacy directive of 2002, the storage of cookies on a user's computer and the subsequent accessing of that information stored in those cookies only required the provision of proper notice to the user and, quote unquote, a right to refuse, or what really was understood to mean an opt-out regime. So the cookies could be set, and as long as there was an opportunity to opt out of them, then that was fine as far as the EU regulators were concerned. And remember, there are data protection authorities in every country that are more or less independent and have enforcement authority. And then there's the Article 29 Working Party, which is a collection of the regulators who provide supervision and advisory opinions. But things, as I say, changed in 2009. In 2009 came the e-privacy directive, or what's known as the cookie directive, which is currently being implemented in many member states. It's supposed to be implemented in all the member states by now. But under the directive is not self-enforcing. There needs to be implementing national legislation. And most of the major industrialized countries in Western Europe and a few in Eastern Europe have implemented the e-cookie directive, and it aims to regulate not just cookies, but the use of technologies, quoting now, information already stored in the terminal equipment of a subscriber or user, by requiring that the subscriber or user concerned has given his or her consent, having been provided with clear and comprehensive information in accordance. And so it is quite different than the situation pre-2009. There needs to be informed consent of users before a cookie may be sent to a user's computer and subsequently accessed. And the e-cookie directive amended the previous version by saying gaining of access to information already stored in the terminal equipment of a subscriber or user is only allowed on the condition that the subscriber or user concerned has given his or her consent, having been provided with clear and comprehensive information in accordance with the EU directive, the overriding privacy directive. And notably in recital 66, if we're going to get into details, said that where it is technically possible and effective in accordance with the relevant provisions of the directive, the user's consent to processing may be expressed by using the appropriate setting of a browser or other application. In other words, it could be implied consent and not necessarily affirmative consent. Yes.
That's an interpretation.
Yes, and so for the first 18 months, well, I just read exactly what the recital 66 said in the e-cookie directive, and that's why for the first 18 months following the 2009 cookie directive, the Commission considered how to implement and to regulate the use of cookies. And so the European cousin, I don't know what your affiliation is with the European version of IAB. Are you separate, or are you the same entity?
We license them all, so we share the same name, but we have absolutely no control over what they do.
Okay, so So the IAB in Europe set up a website that let consumers opt out of receiving ads that were directed as a result of profiling. It launched a site called youronlinechoices.eu, which was supported by members of Interactive Advertising, which was the majority of online advertisers. But the Article 29 Working Party, this supervisory group that I mentioned, said that that wasn't sufficient. In fact, it almost got kind of humorous. It was a little bit like Lucy, Charlie Brown, and the football. Because every time IAB proposed some sort of opt-out regime, saying that opt-in would be too cumbersome, it would result in pop-ups, it would require confusing choices, and people would just click through, the Article 29 Working Party, even before a meeting was scheduled, occurred, it was scheduled and it was about to occur, the Article 29 Working Party would send a letter saying, well, don't come in here and propose an opt-out because we're going to reject it. And the IB would come in and propose an opt-out, and the Article 29 Working Party would reject it. And this happened over and over again. And so the Article 29 Working Party said a consumer's failure to opt out of behavioral ads is not a form of acceptable consent, which was the position of the industry. And so in response to this criticism that from the IAB that explicit consent will result in a barrage of pop-ups, there was in fact a website, I think, that showed what all the pop-ups would look like. The Working Party was fairly constructive, and it proposed alternative methods of obtaining consent, including opt-in cookies, static information banners at the top of a website, a splash screen on entering a website, a click to consent, browser plugins that do not track by default, and group consents along the lines of what's being used in the US, a single interface that would permit users to opt out of multiple networks and at one time. And to further clarify things, in June of this year, this Working Party, the Article 29 Working Party, further explained that there were certain cookies that were exempt from the opt-out requirement, and the kind of cookies that Jonathan were talking about that go to the operation of the website or enhance the user experience or are used for fraud and so forth. And so the idea of opt-in, this opt-in requirement, really permeates the proposed EU regulation, which is currently on the table in Brussels, which is intended to replace the directive governing privacy generally, and would be a region-wide regulation. So this is not an academic issue, this issue of affirmative opt-in consent. It's something that really could control a whole range of things beyond online tracking.
Does the EU regulations permit people to condition access to their site on opting in or not? Or is that still an open question?
I think
if someone doesn't opt in, I can say goodbye or not?
I think that kind of choice is available. I don't think that's been tested.
It's not.
And what I'm going to get to in a minute is how do I, as a lawyer, and my colleagues in Europe, advise clients on how to deal with the cookie directive and its national implementation. And I wanted to talk about just one country's implementation, the UK. There are lots of other countries that have implemented it and in different ways. So the UK believes that there can be assumed consent or implied consent for opt-in. And that's, if you go to BBC or UK websites, many of us have, I guess, since May of this year when it went into effect. It was supposed to be in effect in May 2011. There was a one-year grace period. You'll see a banner that either is a notice or a banner that you have to click on. And people do it, and whether or not it really sinks in what they're doing, it's there, and it provides the information to give them an understanding of why cookies are being set. So this is the implied consent, and the ICO, which is the Commission, the Data Protection Authority in the UK, actually has a really very clear guidance for business and for consumers about this whole scheme. And by the way, they have the ability to fine up to £500,000 for violations of the e-cookie directive as implemented in the UK. But it's not altogether clear that it's being taken that seriously. So there's a website called Silktide. Well, first of all, Trustee conducted an analysis of the 231 top UK websites. They did that in July and August of this year, and to see how many of them were complying with the UK cookie law, and found that only 12% had implemented prominent cookie notice and controls as required. 51% had minimal cookie notices and limited controls, while 37% had implemented neither notice nor controls. Now, part of that may be because the commissioner said, we're really not going to enforce that heavily. As long as you're making an effort, good try. We'll come in, we'll probably suggest you get involved in some educational efforts. But we have the right to fine you if you're really a recidivist. So anyway, there's this website, or this company called Silktide. And Silktide, in light of this trustee study, said that companies that try to adhere to the law are being penalized more than those ignoring it, because companies displaying pop-ups and banners are more likely to scare off customers than those simply doing nothing. So Silktide commented, the idea of the law is a noble one. It's just a shame it was drafted by a team of technically illiterate octogenarians who couldn't find a button on a mouse. And they have,
How to win friends.
and they have a video that basically says, come on, ICO, sue me. And so far, the ICO hasn't risen to the bait, but it might. Meanwhile, in Holland and in France, and I can go through the litany of other countries that have an opt-in requirement, there is now technically a requirement that there be explicit opt-in for the placement of tracking cookies on browsers. To my knowledge, there has not been any real enforcement, and so clients come to us and say, so what do? We want to have a consistent appearing website across the EU. Do we follow the UK model of implied consent? Do we follow the specific requirements in each jurisdiction? And we can channel Clint Eastwood a little bit, not with the empty chair, but by saying, are you feeling lucky? Because we really can't predict. Sometimes the enforcement of the data protection laws in Europe are erratic. Google has got a case before the European Court of Justice because it refused to disable a link to a newspaper article that reported accurately on a foreclosure, because the individual said, I don't want that there. I want to exercise my right to be forgotten. That was a surprise, so you don't know when they're going to enforce. And another Google official has been convicted for, quote unquote, allowing a YouTube video showing a privacy violation to be posted. So there is a real risk that there could be kind of an erratic enforcement effort. But more or less, I think clients are concluding this is something we need to attend to, but it's not a top priority right now, because we don't think there's going to be such robust enforcement. I am not advising anybody to ignore the e-cookie law or the implementing laws in the nation states, but as I do advise clients all the time, and as you do, Ian, you do a risk calculation. Is this something that you're willing to risk for the benefit that you get by having certain technology on your site in a certain way?
So I just wanted to throw out one point on top of what Chris was saying, which is that, again, part of the reason why the process for do not track in the W3C has sort of a footprint is that this is a worldwide web consortium. And so there's plenty of EU players and EU interest in the idea of a simple opt-out mechanism. And so we don't have, actually, again, we don't know what's going through the minds of the EU regulators, but there are definitely, definitely representatives from the Article 29 working group, from the Dutch Data Protection Authority, who are active in the W3C, and therefore we have been assuming all along that one of the things that's going on is that folks are wondering hoping that the W3C header standard would be something that could be adaptable across the pond, and could function, although with different background substantive legal rules,
yes.
But could still function within the EU context as well as.
So that may be the reason why there hasn't been visible enforcement, that the process is still working. If it breaks down, I think Neelie Kroes has said, there's going to be a deadline, and if industry doesn't do something cooperatively, you could start to see enforcement. And just on the point of the different legal regimes in the EU, the law says you have to have consent, actual affirmative consent. In the US, what's going to happen, I think, is that advertisers will say, we will respect the header if what that means is the following. And if they don't do that, then it'll be a deceptive practice under Section 5 of the FTC Act or various state laws. So same result in terms of enforcement, but a very different legal regime.
The self-regulatory efforts
Google has been a part of it all along. Facebook has been as well. Facebook has been a little bit different in that a lot of what they do, and I feel like Jonathan will disagree with him here, a lot of what they do, they classify as what's called first-party data that does not leave their website. So they have not really been an active participant in that because what they do as first-party does not fall under the self-regulatory principles.
What I'm asking is, have they agreed to follow the contract if when it's implemented in one way or another, would they comply with that?
I don't think they've made a statement as of yet.
They're not a member of any of the large online advertising self-regulatory consortia. So they're not lumped in that group of companies that has committed to honor the header in some form. Yeah, they haven't made a public statement. They are a member of the W3C working group. So, presumably if the issues that they're working on in the group are resolved, that they would have an interest in implementing it. I mean, they've certainly been very interested in the process, but no firm statement.
I mean, I would just add, again, because of the distinction between first and third parties and the way that this set up at the beginning with this idea from the FTC that contextual advertising and first-party collection of data was a very different animal than third-party advertising and tracking. That means that a lot of the potential, put it this way, if you were worried about tracking across the board, there would be a whole lot of first parties who would be very, very affected by it. The fact that there is this sort of starting division between first parties and third parties, and then there were some sort of decisions or some temporary consensuses about the shape of first parties, has made many of the larger first parties or many first parties sort of like meh as far as a lot of this other stuff, because it doesn't affect us. Now, this is one of the reasons why decisions like who's within scope are so sort of fateful for the way that the negotiation process goes. I mean, there are 4 big companies in this country, right, like Microsoft, Google, Apple, and Facebook that are right now just sort of really the big kahuna of internet, and they are all in somewhat different places, and even the sort of rivalries or areas where those 4 engage sort of shape or warp the gravitational field of a discussion like do not track in the W3C, quite apart from the specific sort of standard type issues. I mean, I think one way you would always think about these kinds of questions is how does it affect those 4 companies in different ways?
In fact, some people say Microsoft proposed the do not track as a default setting in its Explorer to thumb its nose at Google.
That's right.
And some people have said that the Safari do not track default setting was in Apple's own advertising interest and not a privacy tool necessarily, and not necessarily reflective of the consumer's interests or wishes.
So I guess I can speak to both of those. So the Microsoft measure, internally, there's a lot of conflict. There's no doubt some Microsoft staff saw this as a way to screw with Google. Actually, it turns out for some folks on the Google public policy team, there are so many companies that try to screw with Google. There's actually a term for it. It's achieving a scroogle. Anyways, so there's no doubt that some Microsoft employees were trying to scroogle. But I think there are many, in particular on the law and policy side, who really did see this as the right move for consumers, based on their reading of the fairly robust survey results at this point. I mean, it's not just this one Berkeley study. There's a half dozen or a dozen now showing again and again consumers have a lot of concerns in this space that a default was a better choice, and that furthermore they could kind of distinguish their process or distinguish their browser, a more affirmative case. Like it would be a selling feature, use our product because it's better on privacy than our competitors.
Right. But that assumes people care about privacy, and I'm not sure the market research shows that. Look, I know a lot of people in the law and policy group at Microsoft too. I don't think it's at all clear why they did it, but what I'm suggesting is that there are certainly alternative explanations for both of those techniques. I think, as Lee said, they're competitors, and there could be competitive reasons for these results.
Well, so, I mean, there was an alignment of interest, right? So some people might want to scroogle, some people might want to do something good for consumers. If they both go to the same result, it's like when you piece together the votes on the Supreme Court, right? However you get to 5. So as for Apple's move, so this feature has been in Safari since the first version, since 2004. Like, this was a launch feature of Safari. There were some people who've tried to argue that it was in some way a broadside on the behavioral advertising space or against Google. It seems like it was just a launch feature that never got changed, and that explains why it had some weird loopholes to it.
Right, and it also goes to my point that it didn't reflect my interest, because I kind of liked tailored advertising. I didn't know it existed. So the fact it was set by default was not my preference.
So there's target inefficiency either way, right? So is the default you get tracked, or is the default you don't get tracked? And I think, I mean, let's be honest about what the default debate's about, right? The default debate is about the more users turn on do not track, the more that has the potential to impact the bottom line of certain companies. The ones who've been most vocal about this, by the way, are the ones that are in the business of behavioral targeting. So, for example, there's a company called 33 Across that's written a number of op-eds recently, been very vocal about how it thinks do not track is a bad idea, and in particular how it thinks what Microsoft did was a bad idea. If you're 33 Across, a company that exists to collect information about users' social relationships and then sell the ability to use that information for ad targeting, right? You're a third party and all you do is behavioral ad targeting, then like whatever do not track means, even if you take the industry definition of no behavioral targeting, like do not track directly affects the bottom line. The more people who turn on do not track, the less money you make. If lots of people turn on do not track, maybe you go under.
Right, but you're not then saying the next thing, which is really important. We haven't even mentioned the First Amendment tonight, but that's a fairly important issue, which is...
State action doctrine?
No, it was referred to earlier, which is this advertising does support free access to content. And so a better bottom line for advertisers it also means the greater possibility of free content for consumers. Free video, free text. I mean, that is a fact. And so that's one of the balancing concerns that has to be considered.
So I'm so glad you circled us back to the economic issue, because I had a few things I wanted to say on this. The first is that behavioral advertising is actually a relatively small share of online advertising. There are a bunch of ways you can do online advertising without targeting based on user behavior.
Well, you can't have it both ways, John. Either it's really important to the advertisers because it affects their bottom line, or it doesn't work and it really doesn't make a difference.
My claim was, if you're a company that only does third-party behavioral advertising, do not track is really bad for you. My claim is not that do not track is really bad for all of the free stuff on the web that's great, right? Like, I think everyone on this panel agrees. Like, free webmail, free search, free social network, like, awesome, right? It's like revolution in how services are provided. So the question is, how do not track affects the bottom line of those guys? That's not to say I don't care about the well-being of companies like 33 Across. But from a policy perspective, I think our analysis of what the welfare of those services has to weigh much greater than the welfare of advertising companies that are intermediaries. And so there are a few reasons I wanted to be clear that I think there's not so much reason to be concerned about the economics for these first-party websites. One is that behavioral advertising is a small share of advertising. There's a bunch of ways you can target ads, a bunch of ways people do target ads. So search ads, right? So the ads on Google's website, those aren't third-party behavioral ads. Those are first-party ads. Social advertising, so the ads on Facebook's website, those aren't third-party ads. Those are first-party ads. Contextual advertising, which we touched on. Demographic advertising, so that's like, tell me about the site's audience, like show Rolex ads on the Forbes website. Geographic targeting, so this is someone from San Francisco, show them a San Francisco ad. These are all things you can do without following people around the web. And there's not actually a lot of data to support the claim that behavioral advertising has more value than these. There's been some work surveying advertisers to say, like, okay, what's your perceived return on investment here? And in fact, perceived ROI is about flat between many of the different forms of targeting. So there seems to be a lot of agreement that targeting your ads is a lot better than not targeting your ads. It's not clear that the ROI is greater for OBA as opposed to other forms of targeting. And I want to be very clear about when thinking about ROI, right, there's kind of two important inputs. One is how much do ads cost, and the other is how effective are ads, right? And these point in opposite directions. If ads are more expensive, and you're an advertiser, you might be less likely to spend on them. On the other hand, if they're more effective, you might be more likely to spend on them. And there's not a lot of evidence that OBA, when considering those two factors, actually is a better value proposition for advertisers. There's actually, there have been 2 studies on this, one of which was industry-funded, small sample size, and found the numbers point in opposite directions. And then the other study looked at what happened in the EU and totally got EU law wrong. So if you're interested in that, I have a paper that reviews these studies. But anyway, so the evidence is not really there. And I think it's got to raise a lot of questions. For an industry that's so quantitative, why is it steadfastly refused to give out numbers on the marginal value of OBA to the websites we want to support, right? Where's the data? Okay, so I wanted to be sure to note 3 other reasons. I'm going to try to talk very quickly here why I think the economics shouldn't be a concern. One is there's an elasticity of demand here, right? So if OBA gets harder to do, becomes relatively more expensive, right? Advertisers aren't just going to yank all their money, they're going to move their money elsewhere. And so there's a question of, okay, to the extent OBA gets harder to do, gets more expensive, what are advertisers going to do? We don't have a good model of that, but if online advertising is so much better than other forms of advertising, what's to say they don't shift their money to contextual or demographic or geographic advertising, which is fine. There's also some possibility of a technical fix here. I and others have done a bunch of research on. It turns out you can do forms of behavioral targeting without following users around the web in the ways I described. And so there might be a way to recapture some of this value with different technologies. And last, something we haven't really touched on tonight, there's actually a second component to do not track, a do not track consent mechanism, a DNT:0 header that allows a user to say, I'm cool with you tracking me. So that we have the safety valve built in where we actually make a market around user says I want privacy, and the website says, sorry, you're going to need to get tracked if you want to use my site. And then the user has a choice, right? They can say, okay. Or they can say, no, I'm not going to agree to that deal. Maybe the website says, fine, go away. Maybe the website says, okay, now you have to pay money. But at any rate, so for all of those reasons, I think there's not actually so much cause for concern.
There's an overall assumption that this is on PII, and you may not like to be tracked, but there is a fundamental feeling that all the privacy policies say we will share your PII. What, and a question just to the panel generally, what do you guys think about CRM retargeting? Is that something to be worried about, and is that basically an open door leakage? And is that sort of more theoretical worry, or is that basically, should we assume that a lot of the companies are tracking cookies basically have PII associated with that, or can happen?
So if I understood your question correctly, I have really crappy ears. But I think you're asking about what are the sort of risks in terms of personally identifiable information being captured and leaked and used. I think a lot of what Jonathan said during his presentation was really aimed at when he described the difference between pseudonymity and anonymity. I think he made the correct point that most of the information that we're talking about is linked. It's all linkable because we're talking about these sets of persistent, unique ID cookies that assign you what I think of, he calls it a barcode, I think of it as sort of a license plate for your browser. And you're driving around all the time with this license plate being captured because it's stored in these various places. So the only real question is whether or not it's possible to map that license plate to your true identity. And again, as we saw, there are a lot of ways in which that leaks. If you enter there are direct ways, such as if you enter information on a form that is truthfully about you, then it's possible to have an association.
And there's companies that are actually now taking offline data and associating that with the cookies. That's an actually intentional merger, and then they resell it theoretically anonymously still, or anonymous,
Right.
But
There's certainly also in the industry the phenomenon of data append. So you can, if, again, all depending on what the linking identifier is, but once you get there, if you know my name, certainly then you can go to ChoicePoint and buy data about me. There are public records that will be about me. There will be Facebook profiles. Well, actually, I don't have a Facebook account, but if I did. And actually, one of the ways that the researchers a few years ago showed that there was a real shift, or what we interpret as a real shift in the linkability, was because Facebook itself and other social networks, as part of the sort of in-band dissemination of information to the ad networks and other analytic servers, were including within the data they were sending, say, the profile ID that you had on Facebook, which would then be tied to whatever else. And so someone can go to the profile ID and see, oh, that's Lee Tien or whatever. So for all of those kinds of reasons, we think that there is it's really hard to say that very much of the information is likely to be actually remain in that sort of pseudonymous, we don't know who you are. And then there are also so many advances now in the more interesting areas of re-identification that allow folks with large enough data sets and not that sophisticated technology to, again, sort of map some identities to those for which you already have known lists. There are a lot of really interesting research studies showing how you can take two different social graphs and just sort of begin to identify people because of the shape of the graph.
So on that, two things on that point. One is the Future of Privacy Forum, my think tank, is doing a study with Professor Peter Swire on de-identification and should have a paper out at the end of the year, early part of next year. And the FTC's proposal to deal with this, which it may be simple or simplistic, is that if you say you will de-identify the data, they're going to hold you to that. And so one of their proposed solutions to this issue of re-identification or the lack of anonymity is to have a three-step process, which sounds simple to state. I don't know how easy it is to implement, which is you promise to de-identify, you make sure that third parties with whom you share data will not re-identify, and you have an auditing assessment mechanism to ensure that that system is working. Now, it's really easy to state. The devil, of course, is in the details, but that's kind of the heart of their Section 5 jurisdiction, because you're making a representation to the public, and all the time they enforce against companies that say one thing and do another. Whether that works or not, it relies on good actors, obviously, but there are always going to be bad actors.
And unsurprisingly, the compromise proposal that EFF and Stanford and Mozilla put together for the W3C addresses this part of the way we address the identifiability issue, is to say, on the one hand, we don't want you to use persistent ID cookies, and more generally, to try to enforce a level of unlinkability, which we can technically specify. It's a slippery concept, right? I mean, even in other areas of law, like the health information law with HIPAA, we have a remarkable pairing of standards, because there is one standard that is really quite stringent in terms of specifying what items of data cannot exist. And then there's another standard that's incredibly loosey-goosey that relies purely on a certification by a statistician. And there's not even any reporting to the government as to the methodology of that. It's just, well, we said so, we did a good job. And so this is where the auditing question that you raised, Chris, comes in.
Jennifer had a question, I think.
So going back to Do Not Track, and the discussion that we've been having has been centered mostly around ODA, but, and Jonathan, maybe this is a question also for you, isn't there still some debate in terms of Do Not Track, applying to just Do Not Track anything, analytics and all the other types of uses that you might have for tracking technologies on a website other than ODA?
Absolutely.
And I guess an example, I've not turned on my Do Not Track on any of my browsers, which
Maybe I'll take this in two parts. The first one around do not track going beyond behavioral advertising, and the second about what the practical impact of do not track is right now. With respect to going beyond behavioral advertising, I think there's a real difference of opinion about what do not track should do. Proposals from participants in the W3C working group from the advertising industry have tended to focus on limiting use of information for purposes of behavioral advertising, so ad targeting. Proposals from, I guess, the more advocacy side-ish of the W3C working group have tended to focus on the collection, retention, use of linkable data. And in fact, and I want to be clear, I certainly don't speak for everyone in the W3C working group on the kind of advocacy-ish side, but I would actually allow certain forms of behavioral advertising to continue under do not track. Right? My concern is companies getting the browsing history. It turns out there are technical tricks you can use to do forms of behavioral advertising without collecting users' browsing history. And so do not track should allow that. In the same way it should allow forms of analytics, it should allow forms of social integration that don't require collecting users' browsing history. So,
Focus on the browsing history.
exactly, right. Focus on what I called tracking in my slides, and don't focus on particular business models today. And I share, I like seeing more relevant ads. That's not.
So how is it implemented today?
Okay, so the second part. It varies a lot by site. There are a lot of sites. So do not track doesn't break anything, right? It's this polite signaling mechanism. Your browser's right. There are some companies, about 25 when I last looked, that will honor it by getting rid of an ID cookie, stopping doing fingerprinting, kind of adopting this no collection view. There are a few companies that adopt the no personalization view. So Twitter, for example, will stop personalizing your Twitter time recommendations based on your browsing history, but it does in fact still collect your browsing history. They've tried to term it no collection. It's not no collection. So companies vary. I think by the end of the year we'll see more on the no personalization side owing to the industry commitment. There are a couple sites, most recently this one think tank in DC that tried to make a political statement out of no, you can't use our website, you've got do not track turned on. Outside of people doing it to be obnoxious, I haven't seen anything like that.
But the third-party content could come in as long as you de-identified it or took out any URL and refer header.
Well,
So if you had, in the screen that you showed at the beginning of the presentation about the third-party content coming in, so you could still do that as long as there wasn't any communication.
So the communication's okay. You wouldn't have that ID cookie. The referrer header could actually still get set. So you could do things like contextual advertising, targeted based on the referring URL. I also want to make sure to note, under the do not track proposals, I think one point of certain agreement between all stakeholders is there needs to be some sort of outsourcing exception. There's recognition that we shouldn't expect every website to be an expert in analytics or other sorts of internal operations things, and make sure that there is an ability to use third parties for that. And so there are various forms of cabining, okay, you can use an identifier, but it has to be technically scoped in certain ways to the site. So you can get guarantees it's not getting swapped across sites and some sorts of siloing on the back end. So there are kind of some accommodations there. But anyways, wanted to make sure to point that out.
So we're pretty much out of time, but I know we have one very interested question. We have one. We also had one question that came in sub rosa, and so just if we can get a couple of final comments, I'd like people to think of the following things. Chris, a question had come in about what about in countries like France where it's a tougher environment? What in fact do you do from a business perspective? The other question that I want in the final comments is that we've talked a lot about W3C. I'm not sure everyone in the audience understands. Let's say there is an agreement. What does that mean? Does that mean that everyone now has to follow the standard, or just the stakeholders follow the standard? And any other final thoughts or comments? But the last other question while you're gathering your thoughts.
I think There's been a question or an issue that I think underlies the whole discussion in a way that nobody's addressed, which is just what is it that is creepy, intrusive, undesirable about both invasions of privacy? So, I mean, there are a range of things that people mean by that. There are a range of things that I personally found it a little weird that it knew what ads to shove in front of me. Did I find it horrifying? No. If it reported to somebody that I've been looking at websites dealing with loathsome diseases, still never felt a little worse about it. But I'm not exactly sure if this question of, and maybe this accounts for the European Union's notion of privacy as a fundamental right, is it that we think the government will collect all this information about it and use it in some political oppressive way? But I mean, one way or another, it's not absolutely clear just, and maybe needs to be articulated, just what is it about collection of private information of your behavior that is intrusive or undesirable, and the different answers you get to that are going to affect what kinds of limitations or protections being appropriate.
So Ian, I think we'd be here another 2 hours for that question. It is one of the most important questions in privacy law today. The issue of harm, in Europe, it's a dignity interest. It is a fundamental human right. Some people say here it is only a consumer protection right, and when cases go to, when lawsuits are filed, they're often dismissed because the plaintiffs can't show a cognizable financial injury, and a lot of people say, well, that shouldn't be the test. Dan Solov, who is senior policy advisor at my firm in the privacy practice, writes a lot about harm, and he believes that it should be broader than that. So does David Vladek. So do a lot of very smart and thoughtful people.
But I would, I mean, I actually sort of take issue with the importance of the relevance of the question to the debate. I mean, I know why I think that way. And I know why EFF as an organization thinks that way. But I think that for the question of sort of the do not track as something that a consumer is able to express a preference about, it seems to me that one of the wonderful things about this very sort of light signal approach to it, and then combined with your point about who's bound by it, this is, in the current setting, it's an entirely voluntary system. So in a way, what we're really asking to create or asking to set up is a system where there is an easy way for a consumer to say to any entity, I don't want to be tracked. Now, there's no force of law behind it. Entities that are part of the W3C, I think because it would be a W3C standard, therefore, if they're in it, they would have to abide by it. I think that's the only
I think we agree completely. Privacy is fundamentally about choice. If I think it's harmful, I should have the choice to stop it. And if you don't think it's harmful, then you don't have to worry about it. And the question is, how do we implement our individual powers?
And right now, one of the things that is going on, or sort of the gap that this attempts to respond to, is that when you use your browser, when you interact online, there is no one-click way to say anything, one way or the other, about whether you want your information collected. Right now, there is no voice. This is essentially just creating a voice, and therefore, I mean, not to wax too poetic, but the possibility of a dialogue. That doesn't exist right now. And so companies who are able to use the techniques that Jonathan has detailed can simply collect the data without sort of secure, knowing that the consumer right now doesn't have a way to say anything, and indeed may not even know that they're around.
So Ian, can I give the answer to the French question very quickly and then say au revoir, because I'm actually catching a red eye back to the East Coast. And that is, the CNIL is among the more aggressive data protection authorities enforcing privacy law, and I think if it's a French language site targeted at French citizens, it would be, a company would be well advised to comply with the strict requirements of the French implementation of the e-cookie directive. That would be That would be my advice.
Take it seriously.
Yeah, exactly. And thank you for the opportunity to participate here. I enjoyed it.
Well, and thank you all. On
Thanks.
behalf of the Stanford Center for E-commerce, we're delighted that you came. This has been a great discussion. Thank you very much to the panelists. Feel free to contact them. I know Chris has to run, but the others may be able to stick around. And also, if you have suggestions on future programming for the center, please contact me, contact Roland Vogel, or contact Mark Lemley. And by doing so, you will consent to Stanford's unrestricted use of your information. Thank you.